الجامعة الإفتراضية السورية كتاب Criminal Law القانون الجزائي by عماد الدين محمد. الوحدة التعليمية الثالثة Chapter 3 الشرائح من 1 وحتى 20 From 1 to 20 تقدمت مبادرة ضوء بصوت دانة بيرقدار. Slide 1 Chapter 3 Mensria. Slide 2 Introduction. Mensria is the mental element or fault element of a criminal offense. Translated from Latin, mens means guilty mind. In order to be convicted of a criminal offense, the prosecution must prove that the defendant had the mens for the particular offense charged. The only exception to this rule lies with the prosecution of strict liability offenses, which are offenses where one or more of the actus reus elements does not require a mens rea element. Slide 2. Also introduction. There may be more than one element of mens rea in a criminal offense. For example, the offense of the theft contains two mens rea elements. 1. Dishonesty. 2. Intention to permanently deprive. The mens rea elements of an offense are identified by words such as intentionally, recklessly, maliciously, knowingly, believing, and dishonesty. Slide 4. Introduction. The two most common elements of mens rea are 1. Intention and recklessness. 2. Subjectivity and objectivity. Intention and recklessness are regarded as subjective concepts. A subjective approach examines what the defendant, him or herself, saw or perceived as a consequence of his or her actions. Negligence is an objective concept. An objective approach compares the defendant's actions with those of a hypothetical reasonable person. يوجد مخطط بياني وهو هرم قاعدته negligence ووسطه recklessness وقمته intention. Slide 5. Introduction. In convicting a defendant of a criminal offense, we are usually concerned to know what the defendant's state of mind was. In deciding whether or not a defendant has the mens rea of murder, we ask: did the defendant have malice or aforethought? In other words, did the defendant intend to kill or cause grievous bodily harm? GBH, grievous bodily harm. So, intention is a subjective concept. Slide 6, Introduction. Recklessness has traditionally been regarded as a subjective concept, with the exception of a criminal damage, which included an objective standard of fault for many years. However, since the House of Lords decision in RVG and another in 2003, recklessness in relation to criminal damage has also reverted to being an essentially subjective concept. Subjective recklessness involves the conscious taking of an unjustified risk, which means that the defendant must recognize an unjustified risk and go on to take that risk. Slide 7. Motive. Why? Motive should not be confused with intention, as a defendant's motive is not relevant to his criminal liability. Lord Bridge stated in Maloney 1985 1 AC 905, intention is something quite distinct from motive or desire. A defendant might intend to commit an offense, yet have a good, even admirable motive for doing so. Lord Bridge gave this example. A man who at London airport boards a plane which he knows to be bound for Manchester clearly intends to travel to Manchester, even though Manchester is the last place he wants to be and his motive for boarding the plane is simply to escape pursuit. The possibility that the plane may have engine trouble and be diverted to Luton does not affect the matter. By boarding the Manchester plane, the man conclusively demonstrates his intention to go there, because it is a moral certainty that it is where he will arrive. Slide 8. Motive للاطلاع. So, a person's intention may be different to their desire or motive. The man's motive in the example above is to escape pursuit, and this is also his intention. He has no desire to go to Manchester, no motive, yet he demonstrates his intention to go there by boarding the plane. Motive becomes relevant after conviction, as it might be used in mitigation to reduce the sentence which might be imposed on the offender. It is not usually relevant to the question of intention. In other words, whether the defendant had the appropriate mens rea for the murder. هناك صورة تحتوي المقولة التالية: Motives, what's behind what you do, did, or are about to do. Slide 9. Intention. Intention is the most culpable form of mens rea because it involves acting with the objective or bringing about a consequence, or with the desire to bring about that consequence and foresight that your actions are virtually certain to do so. A defendant who is charged with a serious criminal offense, such as murder, has his or her liberty at stake. If convicted, he or she will be sentenced to imprisonment for life with a tariff recommended by the trial judge. A tariff is the minimum period to be served to satisfy the sentencing objectives of deterrence and retribution before the prisoner is eligible for parole. Where such a conviction and severe penalty turns on whether or not the defendant had the necessary intention to kill or cause grievous bodily harm, i.e. the mens rea of murder, clarity and precision in the law is clearly of the utmost importance. Slide 10. Intention. Criminal law requires two types of intention. 1. Direct intent. 2. Oblique or indirect intent. Direct intent is one's aim or purpose. For example, when you state you have an intention to do an act, such as go to the cinema, you mean that it is your aim or purpose to go to the cinema, or that you have a desire to go to the cinema. This is your direct intention. In the vast majority of cases where the intention of the defendant is in question, the court is concerned with direct intent. In such cases, the everyday meaning of intention is applied. Consequently, the judge does not need to give the jury any special direction on intention, but will ask the jury to apply their common sense of its meaning. Slide 11. Oblique intention, the current law. Oblique intent is a less common form of intention. It does not involve a person's aim, purpose, or the desire to do an act. However, it does require the consequences of the defendant's actions to be virtually certain to occur, along with the defendant's appreciation that they are so. The precise meaning of oblique intention has caused confusion in the courts. There are two issues which have caused problems for the courts. 1. What degree of foresight is required for oblique intent? The courts have held that the defendant must foresee the consequences as virtually certain to occur, according to Woolen 1999. 2. Does foresight of the consequences equate to intention in law or evidence of intention? Slide 12. Oblique intent, the current law. If the defendant does foresee the consequences as virtually certain to occur, Is he or she taken to have intended those consequences, or is his or her foresight merely evidence from which the jury may infer intention? The courts have held that foresight of the consequences is a rule of evidence. This means that a defendant's foresight of the consequences as virtually certain to occur is evidence from which the jury may infer that he or she intended those consequences. The jury are not bound by law to find that he or she did intend those consequences, but they may infer that he or she did. Slide 13. Oblique Intent, the current law. The current law on oblique intent is derived from the following cases. 1. Nedrick 1986, 1 WLR 1025. 2. Woolen 1999, 1 AC 82. The current law on oblique intent is referred to as the virtual certainty test. As most of the authorities on oblique intent are murder cases, it is necessary at this stage to remind ourselves that the mens rea for murder is malicious afterthought, commonly expressed today as an intention to kill or cause GBH, grievous bodily harm. Slide 14. للإطلاع, oblique intent, the development of the law. The degree of foresight required for oblique intention has not always been clear, and intention is a subjective concept. It is important for students to please carefully read and familiarize themselves with the following important cases for examples and a clearer understanding. 1. DPP v. Smith, 1961 AC 290. 2. Hayem v. DPP, 1975 1 AC 55. 3. Moloney, 1985 1 AC 905. 4. Hancock and Shanklin, 1986 AC 455. Slide 15. لإطلاع, oblique intent, the development of the law. Consider the following question posed by Lord Bridge in Moloney, 1985. A tourist plants a bomb which is timed to explode 12 hours later. The tourist informs the police so that the building can be evacuated. A bomb disposal expert trying to defuse the bomb is killed. Is the tourist guilty of murder? Would you answer differently if the bomb was planted in a busy shopping center and timed to explode at a midday on a Saturday? Would your answer be different if the tourist give his or her warning 5 minutes before the bomb is timed to explode, or if he or she gives the warning 12 hours before the bomb is due to explode? Slide 16. للإطلاع, intention, summary. If the jury 1. Feel sure that death or serious bodily harm was a virtual certainty as a result of the defendant's actions A and D. 2. That the defendant appreciated this, then the jury is entitled to find that the defendant has the mens rea for the murder, intention to kill or cause GBH. It is clear from the direction in the Nedrick and Woolen cases that a defendant will have oblique intent where the consequence is actually virtually certain to occur objectively, and the defendant appreciates this. Slide 17. للإطلاع, intention, summary. However, a defendant will also have oblique intent where he or she believes that the consequence is virtually certain, although it is actually unlikely to occur in reality, and then it does occur. For example, I believe that it is virtually certain that I will be able to shoot my friend who is standing a distance away from me. In fact, The chances of me actually hitting my friend are unlikely from such a distance. If I do manage to shoot my friend, surely I must have had oblique intent in relation to that result. The first objective question is only relevant where there is no other evidence of the defendant's state of mind. In other words, whether he or she foresaw the consequences as virtually certain, so this has to be inferred. Slide 18. Intention Reform. In 2006, the Law Commission proposed that the meaning of intention should be put on a statutory footing as follows. 1. A person should be taken to intend a result if he or she acts in order to bring that result about. 2. In cases where the judge believes that justice may not be done unless an expanded understanding of intention is given, the jury should be directed as follows. An intention to bring about a result may be found if it is shown that the defendant thought that the result was a virtually certain consequence of his or her action. The first statement refers to direct intention and is not controversial. The second statement relates to oblique intent. The Law Commission took the view that the virtual certainty test should be applied with respect to oblique intent, in accordance with Nedrick and Woolen. The Law Commission proposed that this should be a rule of evidence rather than one of substantive law. The defendant's foresight of a result as a virtually certain consequence is evidence from which the jury may find intention. Slide 19. Recklessness. Recklessness involves the taking of an unjustified or unreasonable risk. Recklessness is often a less culpable form of mens rea than intention, as it involves foresight of possible or probable consequences, instead of desire or foresight of virtual certain consequences. Subjective or advertent recklessness is foreseeing the risk of a consequence occurring as a result of one's actions and proceeding to take that unjustified or unreasonable risk. هناك مخطط بياني هرمي أسفله low culpability وفي القمة high culpability. من الأسفل يوجد strict liability ثم negligence ثم gross negligence و recklessness وفي القمة intention. Slide 20. Recklessness. The current law on recklessness is that there is one subjective standard of recklessness which applies to most criminal offenses requiring recklessness as part of the mens rea. For over 20 years, there existed two tests of recklessness. One is subjective, advertent recklessness, the other one containing an additional objective limb, inadvertent recklessness. Each test applied to different offenses. The subjective standard of recklessness is referred to as Cunningham Recklessness, and this test applies to most offenses. House of Lords, now known as the Supreme Court decision in Metropolitan Police Commissioner V. Caldwell in 1981, provided a second intent of recklessness which applied to criminal damage. نهاية التسجيل from slide 1 to slide 20.